resident in Carson City.
Rebecca Wagner.
Dave Milton.
And I'm Linda Burnshaw in Las Vegas. Item 1A is time for comments from the general public on topics that pertain to items on this agenda. I have cards. Do you have cards, Commissioner Wagner?
I do, I have one.
Okay, so let me go ahead then. The Commission welcomes comment from all persons. However, please recognize the Commission receives evidence through a formal process. The hearings or investigations for all matters that will be discussed on this agenda have already been conducted, and draft orders or memoranda have been prepared on the basis of the record created at the hearing on the final results of staff's investigations. The Commission appreciates any feedback from the public that comments made today cannot be treated as formal evidence. Members of the public desiring to comment, please state your name on the record. Comments shall only address topics that are relevant to or within the authority of the Commission. Speakers shall not repeat prior comments made during the agenda. Comments are limited to 3 minutes per speaker, and the speaker's allotted 3 minutes cannot be transferred to another speaker. When the allotted 3 minutes has ended, the individual will stop speaking. Why don't we go up north first?
Mr. Bolt.
For the record, Fred Bolt. A number of unanswered questions emerged from the Executive Director's annual assessment report contained in Agenda Item 7A. Hopefully they will be addressed when the report is presented to the Commission later today. An over 28% increase in revenue line 3716 inspection fees rail assessment appears excessive and an undue burden on railroads without any context or explanation. What is the nexus between the $23,000 increase for in-state travel expenditures and just an $11,600 decline in vehicle operation expenditures? Is a 25% drop in expert consultants and a 31% drop in information services going to compromise PUC work product quality and productivity? On April 30th of this year, the Executive Director recommended over $150,000 of annual compensation increases for a handful of Commission staff. Proposed personnel services expenditures reflect a fiscal year 14 to 15 increase of only $71,000. The following items need clarification. What is the PUC's proposed full-time equivalent staffing count for fiscal year 14 and 15? Why aren't they listed in Attachment A? Were there any extraneous positions in previous years now being proposed for elimination? How long and at what cumulative cost was the PUC funding any extraneous staff positions? Are any unfilled positions going to create work backlogs in order to give a few individual salary increases of as much as 24%? How many positions are being temporarily or permanently eliminated to accomplish the fiscal feat of paying $150,000 plus of increases when compensation expense rises by just $71,000 year over year? Are fringe benefits included in the personnel services line item? Will over 3/4 of PUC staff receive no compensation increases of any type in fiscal year 15? Answers to these questions would bring clarity to an incomplete recommendation. I will submit exhibits at the end of this meeting for inclusion in the official record. Per NRS 241.035, Section 1C, I will provide a written copy of my oral comments for inclusion in this meeting's permanent record. Thank you.
Thank you, Mr. Bolt. Is there anybody else in Carson City? Okay, Chairman, I don't have anyone else coming forward.
Okay, thank you. Ms. DeFazio, NTF, and PUC.
No, only one.
Just one?
It's fine.
Commissioners, on docket ending 02032 regarding the charges for the kiosks, I noticed that with third party there was a substantial reduction, and I think that's fair, reasonable, and just. But the question is, when they say third party and they're referencing Western Union, what about when you go to the supermarket to pay the bill and it's through Western Union? That's still a third party, and currently we're not being charged. So if there is a third party and they're referencing Western Union, are we now going to have to pay when we go to the food store to pay our bill? That's it.
Okay, thank you, Ms. Fazio. Carol Singh.
Oh. Good morning. On June 5th, a company named Direct Communications from Arizona came to our house and discussed the possibility of us obtaining bundles to maximize our savings. I suspect these people called CenturyLink and used my name in order to set up a bundle. And what happened was, and I'll read the time frames here, on 9/9/2013 at 10:56 a.m., Tom of the Winback Department of CenturyLink at 800-590-5420 said that I had called in and ordered my telephone lines ported over from Cox Communications. This call was for third-party verified, he said. I was in a class on 9/9/2013 and have attendance sheets which have been submitted to the PUC to prove that I was there. The workout time at this time is a gym in Heritage Senior Center, Henderson, Nevada, from 10:30 a.m. to 11:20 a.m. On 10/3/2013, my numbers were slammed from Cox Communications to CenturyLink without my knowledge. I was without a dial tone for our home business phone lines from 10/4/2013 until 10/24/2013, when Cox got the numbers back. They are 702-314-0539 and 855-314-0539. However, the fax line for incoming calls was not hooked up that day, so we had been without fax service from 10/24/2013 until 11/25/2013, when it was reconnected to Cox. Besides being without phone service for extended periods of time, I received 2 bills from CenturyLink for $487.78, invoice number 9778, and $96.31 for $66.33 invoice number. When I asked what the bills were for, I was advised they were for services I chose not to use. Also, I was informed I have a verbal contract for internet services, which I did have with CenturyLink until 3/2015. That was the only service I had with CenturyLink, was the internet service. And I left CenturyLink because of the miscommunication, which I have not been able to rectify. And so I took the internet service out. I do not remember the verbal contract. I'm certainly not going to say it doesn't exist, but I don't remember it. I was with CenturyLink for several years, and we were on a business contract with them for home business services. So basically, the problem is that I have absolutely no objection to paying for internet services that I've used, but I have a very serious objection to paying for services that I chose not to use when I was unaware that I had been transferred over to CenturyLink. That's the highlights. I hope it's sufficient. I have other details if it isn't.
Thank you, Ms. Singh.
You're welcome. Pardon me, do I stay or do I go?
Oh, go ahead, you can go and have a seat.
Okay.
Thank you. All right, agenda item 2A is mine, and it's docket 13-09012. This is the rulemaking that we opened as sort of the adjunct to the customer service investigation that I also opened. It's the 12-01005 docket. And coming out of that docket was also, in the meth power generator case, was the issue associated with business place offices and the utility. We went ahead and decided to open up rulemaking, and what you have before you today is essentially an order that would basically say, we don't think it's time to close down offices, that there still needs to be some quantifiable information that needs to be provided. That's identified in the order. But until that's provided, and it's, folks make a better case, that we should leave at least one business office open in, for the energy utilities. It would not change a rule. Essentially, we leave the rules exactly as they are and make it clear that how we're interpreting the rule, which is we require the maintenance of a business office. If you have any questions, I'm here to answer them.
I have none.
I have none.
Okay. And I would move we close the docket and issue the order.
Second?
Concur.
Item 2B is brought to us by Commissioner Wagner.
Thank you, Chairman. Item 2B is 13-12001, and this is the application of Locust Telecommunications, Inc. for authority to operate as a competitive supplier of telecommunications service within the state of Nevada. What you have here before you today is a stipulation resolving the issues with the application. The primary issue that we have been consistently raising is good regulatory citizenship pursuant to the stipulation. Locust has affirmed that they are going to try and be a good regulatory citizen. They've hired additional staff, enhanced their regulatory calendar, and informed personnel of the requirements of regulatory filings in Nevada. So that's the quick snapshot, and I'm happy to answer any questions.
Any questions or comments?
I have none.
Should I have a motion?
I do. I move that we accept the stipulation, grant the application as modified by the stipulation, and issue the associated order.
Second.
Concur.
Item 2C is brought to us by Commissioner Noble.
Item 2C is docket number 12-10013, the investigation regarding voltage and volt-ampere reactive control optimization. We held a workshop on May 8th, and all the participants recommended moving forward. Those comments are summarized in a report, and the report recommends for the Commission order NV Energy to proceed with the pilot program. I'd be happy to try and answer any questions or comments you might have.
Any questions or comments?
I have none.
Neither do I. Do you have a motion?
I would move that we approve the report as filed and adopt the recommendations as filed and issue the appropriate order.
Second.
Concur?
Items 2D, 2E, and 2F are brought to us pursuant to Section 252 of the Telecommunications Act of 1996 and can be voted upon without any further discussion unless any commissioner has questions or comments. Anything?
I have none.
I have none.
Hearing no requests, I move that we grant the joint petitions, approve the amendments and agreement, and issue the orders.
Second?
Concur.
Item 3A is brought to us by Hearing Officer Lamojo.
Item 3A is docket number 13-09006, the show cause proceeding to determine why Spark Energy Gas LP should not be found to have violated NRS 703.191, 704.033, 703.035, and 704.998, and NAC 704.225 and 704.79523, and be fined for such violations. The Commission already issued an order accepting a stipulation in this matter that did assess past due annual assessments and late fees. Spark Energy Gas missed the compliance deadlines for submittal of those items, and another hearing was held in the matter, at which time a second stipulation was presented that recommends imposition of a $500 fine, and a draft order is included for your consideration.
Any questions or comments?
I have none.
I have none.
I would move we approve the hearing officer's proposed order as filed, accept the stipulation, and issue the order.
Second?
Concur.
General Counsel items 4A, 4B, 4C, and 4D are brought to us by General Counsel and can be voted on without any further discussion, unless any commissioner wants to pull one out for further consideration.
Chairman, I'd like to pull 4B, and then I think we should probably pull 4D, because I think you have a conflict on that one.
That's correct. Okay, so let's go ahead and vote 4A and 4C. I would move the commission accept the recommendations contained in General Counsel's briefing memos regarding items 4A and 4C and issue the appropriate orders.
Second?
Concur.
Okay. Item 4B, Mr. Fox?
And Chairman, I don't need a presentation on it. I wanted
Okay.
to pull it up just to explain why I wouldn't be supporting the proposed order. In looking at this, I can appreciate that General Counsel, I think, has done it, what I would say, made lemonade out of lemons. I think that the intent of this petition was to affect the general rate case with a finding that it can't coincide or should not coincide with the general rate case. I think we should let the net energy metering study stay its course, and then once we have the facts from that, then we can determine more appropriately what should or should not be done. I think this is premature. I think it tends to, in my opinion, tries to circumvent the legislative intent, and I just think it's better suited to address these issues after we have the completed study. So that's why I won't be supporting this order.
Anything, Commissioner Noble?
Since I've got the study, I'm fine with this being consolidated with it. The study, final study is supposed to be filed July 1st. I anticipate having one or more workshops after that, using the results of that study to gather information on what, if any, recommendations to make to the legislature for changes to net metering statutes consistent with AB 428. This obviously brings up some discussions on some aspects that may or may not require statutory changes. So I'm fine with addressing these issues in docket 1403-026 in those consolidated proceedings.
Okay. I had presumed, when I read through BCP's petition, that they're kind of signaling to some possible interveners that that might be an issue in the case that they want to raise. In the Nevada Power Generation case, I have no idea. But I do remember a number of cases where staff or BCP would raise something in their testimony. Most notable was the park in Henderson for disallowance. The folks in Henderson were very upset because they didn't know it was going to be an issue in the case. And they hadn't intervened in the case, and so they felt like they had their rights of due process had been violated. So that's kind of how I had kind of viewed it as sort of this kind of stopgap measure for what might happen in the Nevada Power Generation case. But I can certainly understand Commissioner Wagner's point of view as well as Commissioner Noble's. So given that, I'm willing to support General Counsel's recommendation if Commissioner Noble feels comfortable having it in his docket.
That's fine.
And I'm still going to oppose on principle, but there could be a number of options, but you're not going to preclude anyone just because you have this associated with it. I know, without saying that.
It'll be wide open.
Okay.
I expect a robust discussion.
I suspect it will. I suspect it will be. Okay, then I would move that we, let's see, where are we at here? Move that we accept the recommendation contained in General Counsel's briefing memo regarding item 4B.
Second.
And I'll dissent.
And sorry, and issue the appropriate order.
Second.
And I'll dissent based on my explanation.
Okay, thank you, Commissioner Wagner. Commissioner Noble. And Commissioner Wagner, could you go forward with item 4D?
Sure. Item 4B, I think we don't need any explanation on it unless you... 4D, I'm sorry, do you need to pull that out for any other purposes? Okay, then I recommend that we accept staff's recommendations and grant the petition as filed and issue the appropriate order.
Second.
Regulatory operations staff items 5A, 5B, 6A, 6B, 6C, 6D, 6E, 6F, 6G, 6H, 6I, 6J, 6K, 6L, 6M, 6N, and 6O are brought to us by regulatory operations staff and can be voted on without further comment unless any commission wants to pull them out for further consideration.
I do not.
I have none.
I don't have anything necessary to pull out, but I do have, find it here, a couple of comments. 5A. This is the consumer complaint with regard to CenturyLink and Miss C. And staff's, the briefing memo was fascinating, but I do think staff has the right results. I mean, the only issue that was there before is the company has agreed to reverse the charges, so that would make the issue associated with the voice information moot. And we do have no jurisdiction over broadband and internet, so we can't even act on that. So staff's recommendation, if you see, is the appropriate one. But I didn't want Ms. Singh to understand that we really do not have jurisdiction over broadband, so we have no ability to act on that. And then I also read with interest Mr. Volz's response in his consumer complaint. And I believe that Mr. Jacobson, I've talked with the consumer advocate, Mr. Jacobson I think is on hand in the Carson City office to have a conversation with Mr. Volz. He seems to have concern about various deferred energy cases that are changing the rate. And I think it would be very helpful for Mr. Jacobson to kind of explain to him how we do deferred energy and how that doesn't affect general rates. So I just want to throw that out there, make sure Mr. Jacobson is there, Mr. Volz is aware of that. If he's willing to talk to Mr. Jacobson, that'd be great. And that's all I have. So there's no pulling out of the other ones, right? Okay. Then I would move that the commission accept the recommendations contained in staff's briefing memos regarding items 5A, 5B, 6A, 6B, 6C, 6D, 6E, 6F, 6G, 6H, 6I, 6J, 6K, 6L, 6M, 6N, and 6O, and issue the appropriate orders.
Second.
Concur.
Item 7A is brought to us by the Commission's Executive Director, Ms. Jackson.
Thank you, Chairman. Pursuant to NRS 704.033 and NRS 704.035, the Commission is required to levy and collect an annual assessment against public utilities in the state and to notify those utilities of the assessment rate by June 15th for the following fiscal year. The recommendation before you today is a reduction to the assessment rate from fiscal year 2014 of 2.59 mils to 2.55 mils for fiscal year 2015, with an anticipated revenue collection of approximately $10 million, which is less than what was legislatively approved. The ability to reduce the mill assessment is due in large part to internal efficiencies as well as higher than projected revenue collections. Specifically, Commission employees have played a large part in the Commission's ability to lower the assessment rate. Due to employee commitment, our fiscal year-end 2014 budget closing projections show expenditures below our legislatively approved budget, with real-life savings in the categories of personnel services, in-state travel, as well as expert consultants. These savings are significant because the cost of doing business have increased. Also, revenue collections were higher than originally projected due to the Commission's collection efforts of past due assessments and the transfer of monies from environmental protection from the Baby Dump and the Nevada test site. Additionally, the Commission is responsible for collecting the annual assessment for the Bureau of Consumer Protection. The Bureau of Consumer Protection has requested an annual assessment rate of 0.74 mils for a total collection rate of 3.29 mils. Attachment A in your briefing materials is a spreadsheet which shows the projected revenues, the expenditures and reserve balance projected to the end of fiscal year 2014, as well as the legislatively approved budget amounts for fiscal year 2015. Attachment B is the annual assessment revenue history worksheet, and attachment C is the estimated impact on customers. I'm available to answer any questions the Commission may have.
Any questions?
I have none.
I have none.
Okay. Then I would move we approve the Executive Director's recommendation and adopt the assessment of utilities for fiscal year 2015 as recommended.
Second.
Concur.
Item 8A is time for comments from the general public on any topic that jurisdictional to the Commission. Any members of the public wish to make a statement in Carson City?
Yes, Chairman, I have Mr. Volz.
Yes, for the record, Fred Volz. The PUC could be receiving constructive public input on a regular basis, but its current policies do not encourage or even allow such input. In fact, the general public is regularly told that their comments cannot be considered in any pending regulatory action because they can't offer evidence and/or lack formal credentials or work background as expert witnesses. This week's hearings on docket 14-02004, the annual plan for alternative energy programs, demonstrated the folly of prohibiting public comments. The public had no ability to speak during these hearings because of the quasi-judicial obstacle, yet there were alternatives, analyses, questions, and facts which none of the parties present raised. Some of the exclusions include, there is no guarantee that public school systems installing solar panels won't reduce the target school's existing budget by the electricity savings, adding nothing to the target school's funding. Even if school district administration allows the individual school to keep energy savings and their other spending authority, how do those savings directly benefit low-income children? Why isn't the ROI, return on investment, for installed projects being tracked and published by the PUCN? Isn't it better public policy to stretch finite funding and benefit more Nevadans through alternative energy projects by having third-party providers leverage grant money? Isn't a subsidized alternative energy project better fulfilling AB 428's requirements when tangible benefits flow directly to the target audience? If third-party system providers or manufacturers go out of business before the useful lives of panels, inverters, and other system components come to an end, who will keep operations and maintenance promises? A maintenance insurance policy, posted bond, some other mechanism? Who pays for these backstops, and are they necessary? Are administrative costs appropriate given the level of program funding? How can public school systems be given financial responsibility for operations and maintenance expenses when they lack the funds to adequately maintain their existing facilities? Why aren't stakeholders tasked with working out program details and proposing alternative paths forward before a final decision by the PUC? This is the more efficient business model rather than the PUC approving a potentially unworkable construct and then trying to fill in all the operating details through unrealistically constrained stakeholder groups. This one instance demonstrates that ratepayers should have a participative role in any policy-making action taken by the PUC. Any member of the public who is served by a PUC-regulated utility is a person whose substantial interest may be affected by the PUC's decisions and should qualify for intervener status in any PUC rulemaking procedure. Per NRS, I'm requesting inclusion of these comments in the permanent record. Thank you.
Thank you, Mr. Wolf. Anybody else in Carson City? No one's coming forward, Chairman.
Okay, and Mr. Fazio, NTEF, PUC Russia.
Angel DeFazio, I continue to be taken back by the attitude of the PUC General's Counsel in dealing with public input and public accommodations. Retaliation has now become the answer when law and facts don't support a legal stance, as represented by the latest unsubstantiated decree that only one person can represent one entity. The ratepayers paid for PUC and operations through mill. None of us can or should forget that reality. We have a justifiable issue from May 19th, Legislative Committee on Energy meeting attended by the General Counsel. During the attendance at the meeting, the General Counsel was playing on Facebook, posted a cartoon, chatted with Assembly David Bozian, probably on their taxpayer-funded smartphone. At 11:47 a.m., Bozian typed, "Oh, come on, is this committee that boring?" At 11:49, the General Counsel wrote, "Yes. You need to know that I have documented every second and page visit of people visiting the NTES webpage. Should ratepayers fund public servants' entertainment during work time? I have an absolute snapshot of the Facebook page showing that they were playing during work time. You should also know that I've been in contact with the Las Vegas building manager over the water intrusion that the PUC officials never reported to building management. On March 31st, in their reply to the State Attorney General concerning a recent open meeting violation, the PUC General Counsel said my statement or any other entity's statement can be read into the record. Therefore, I am dropping off statements of groups that want to be read into the record. This is no different than when I electronically file requests to be commenters or dockets. Now, the question is, who shall I give them to have them read into the record?
Ms. Levitt?
Ms. DeFazio, I believe that the statement was that you could provide written comments if your comments went beyond the allotted period of time, and we will place them in the record. So you may give them to the person designated for the consumer division in Las Vegas, and they will be placed in the record.
I'm sorry, I have the actual copy of the response, and it says, Ms. DeFazio could have requested that her statement be read into the record. So, was there a false statement to the Attorney General, or do the statements get read? Simple question. Verifiable, your General Counsel made this statement.
Thank you, Ms. DeFazio, for that clarification. She sent you that email in response to your request to put comments into the record when you couldn't appear personally. Her response was that you could have had someone appear or had someone from the commission read those comments into the record in that specific situation. Today those facts do not apply.
That was not in an email. It is on the official letterhead of the
Can we take this
PUC.
offline? I don't see that this is an appropriate debate. I think there's a miscommunication. I think the response that Ms. DeFazio is referring to was specific to the facts at that time. I don't think that that was if there was a situation, Ms. DeFazio, where you weren't going to be able to participate, then you could have requested having someone read the comments in. But because you are here, and neither one of us are lawyers, so you can shake your head all you want, but that's kind of how I see it, and this is not a productive use of our time. I think those written comments, that if you have them available, we can put them in the record for today and reflect that those were comments that you had wanted to make at a previous meeting. I think that would be a reasonable solution.
These are not from a prior meeting. These are
Okay,
relevant to today.
Then you can put those into the comment today. Because you're here in person, I don't see why we would have someone read them into the record. I think Ms. Tanner was trying to provide an alternative, but I don't, since you're here today, we can accept them for the record.
Okay.
Thank you.
Mr. Fazio, why don't you give them to Mr. Fox so we can be able to review them?
I have an email that was sent to Mrs. Tanner, I believe, late last night. I'm on the record for the NTEF. My name is David L. Hopper, PhD, FAA-VM, FAA-PH, FIA-MB, CP, FA-BMT, FAAS.
Mr. Fazio, I'm sorry, before you go through the alphabet soup there, it sounds like it's all the acronyms that we come up with in this industry. My understanding, pursuant to our notice, that it was one person and not multiple entities. And I guess this is at the discretion of the chairman.
Until that statement is clearly defined, I have also notified the State Attorney General about the impedance of public comment. Mr. Taylor said that he will be looking into it, And if a statement is made about only persons or people appearing as public, you'll have to review Citizens United and track back when the open meeting law was started. So
Okay, so,
predicated on
That's
the
nice, but-
response, the NTEF wants this read into the record. And if you don't want to do it, that's fine. I will send this up to the Attorney General's office.
which
Mr.
is the
Mr.
proper place
Fazio.
for this to be adjudicated?
Mr. Fazio, the notice for this agenda says clearly 3 minutes per speaker, which was changed from what we had before. It was per person. Now it says per speaker, so it's mirroring what the language of the legislative folks. So under this notice is per speaker, not per person. So so there is all of your entities, yourself, PUC, Watchdogs, and NTEF, needs to be represented within that 3-minute period. So I think that it's appropriate, this is going to be an issue before the Attorney General's office, we have a clean record on this, so that when the Attorney General can advise us, they'll know what we're doing. So you've had your 3 minutes per speaker. I know you disagree with this.
This is a corporation. I am an
But here's,
individual.
yes, you are, but the notice says per speaker, not per person.
Then
If it continued to say per person, I would agree with you that it would be necessary for me to give NTEF 3 minutes. But now the notice says per speaker. So all of the entities you've identified would have to be within that 3-minute period. We're adjourned.